Now, in this video, we will discuss Sale of Goods Act, 1930 Act. So, here two terms are coming into picture. One is called contract of sale and another is called agreement to sale of goods. So, these two aspects is joined together and it is consolidated called Sales of Goods Act. First called contract of sale. What is called sale? If the goods are transferred immediately from seller to the buyer, it is called sale. So, once there is a sale, there is a contract between the seller and the purchaser. So, here it is called contract of sale, and anything that is agreed to for the sale to be effected in future, that is called agreement for sale of goods. Any goods that is to be sold in future, and temporarily something is sold today and the rest portion will be sold in later. So, that is called coming under agreement to sell. So, once there is a agreement, the agreement will be executed between the parties and the details of terms and conditions of contract of sale will be mentioned therein. Accordingly, the agreement of goods, agreement of sale of goods, that starts. So, here two things are coming into operation. One thing is called instantaneous sale, immediate sale, and the another is called agreement to sell. So, you can say the sale is immediately a contract is executed. That's why it is called a executed contract. So, sale is also otherwise called a contract in executed form. But in case of the agreement to sell, this sale will be completed in future. So, there is an agreement today. So, that's why it is called executory contract. So, basically the main difference between the sale and agreement to sell is that is sale is called executed contract and the agreement to sell is a executory contract, because the contract will be executed in future. That means today's part performance of contract is there, rest will be completed in future. That's why certain differences are there. The sale and agreement to sales are categorized accordingly. So, it is a executed contract sale and executory contract, that is a agreement to sell. The sale, in case of sale, it creates a right in rem. That means anybody has got a right in rem means right of general public. Once a contract of sale is made between the seller and purchaser, on the death of something, suppose the purchaser dies during the contract, the legal heirs or legal representative, they can also represent the purchaser. So, the right in rem. So, in case of all sale, it creates a right in rem. But in case of this agreement to sell, it is because it is between one party, so it creates right in person. So, the right of the person is only involved in case of agreement to sell. But in case of sale, the seller have no right to resell. That means once a sale deed is executed, the other methods of remedy is available under law, but the seller has got absolutely no right to resell the property, whatever that is agreed between the party and what is the terms and conditions of sale of goods in case of sale. But in case of this agreement to sell, the seller has got right to resell. But in case of this agreement to sell, because the sale is not completed one, the seller has got right to resell. In case of any deviation from the purchaser, the seller has got option to resell the property. That means he can sell the property in different form. So, these are certain basic difference between sale and agreement to sell. So, now let us do some sale of goods. The second aspect of this act is called goods, relating to goods. Now, let us discuss what are the different types of goods available under this act. Goods, it is having different categories. First is called existing goods. Whatever any goods that is available for transaction, that is called existing goods. For that existing goods, when the goods is practically available, the sale can be created. Either the agreement to sell can be created or sale of goods can be created. So, that is called existing goods. Certain goods, for that the agreement can be created today because there is chances of availability of goods in future. Suppose a case suit is pending before the court. If suppose a person plaintiff says, after getting a decree, I will sell the goods to you. So, it is called, so at that time it is a future goods. That means the property can be obtained in future after the getting a decree. Let us say the producer has planted something and the produce will come after 3 to 4 months. So, he can execute the agreement today and he can execute the agreement today anticipating whatever product he will derive in future. For that he can execute an agreement to sell. So, future goods also there. Then another goods is called, that is called contingent goods. That means if anything that will be acquired in certain contingency. Suppose in one policy somebody's person is going to get some property, so he can enter into a transaction of that contingent goods, because that contingency is dependent on certain eventuality. That means he is writing that, or he is agreeing that on certain, on getting some eventuality, will acquire some property, accordingly he can enter into a contract for these goods, that is called contingent goods. So basically the goods are classified like this: existing, future and contingency goods. So now let us discuss very important aspect of this Sale of Goods Act, that is called conditions and warranty. These things are very important because condition, so what is called condition? First, condition is a stipulation essential to main purpose of the contract. That means any condition that is there, that is a main purpose of entering into contract. So condition must be fulfilled. Once the condition is breached or that is violated, the breach thereof gives a right to repudiate the entire contract. Once there is a breach of this condition, the entire contract can be repudiated or it can be cancelled, because there is no alternative remedy available to the person who has been breached. So here, suppose I am giving a very good example of this. Suppose somebody has ordered for wedding cards, invitation marriage card. Suppose marriage date is fixed to January 20th. So there is a stipulation in the contract that he has to supply the cards before, at least before 5 days of the marriage. Suppose marriage is going to be scheduled on 20th January, he is bound, the printer is bound to supply by 15th January. Suppose he fails to supply that during that time and is delivering the property, that goods on 20th, so definitely that goods is having no purpose for the person who has ordered. So definitely the entire contract can be repudiated. He can entirely cancel the contract. So in case of condition, if there is any breach or violation of condition, the only alternative remedy is available only for repudiation of the contract. So that is called condition. And second portion is warranty. Warranty is a stipulation collateral to the main purpose of the contract. The main contract remain exist, but that is collaterally exist. That means suppose a contract of breach of thereof gets right a party to claim damage but not to repudiate the code. So contract. So in this case, only damage can be claimed, but contract cannot be repudiated or contract cannot be cancelled. So this is called warranty. Suppose somebody has given a publication or this printing of these visiting cards. A particular date is given. If the printer is unable to supply on that particular date, he can extend for another 5 days or 7 days. So in that case, that does not mean the printing will be, entire thing will be this repudiated. It will be cancelled. There is nothing. It can, suppose there is a delay, at best he can claim some damages. So that is called claiming of damage. But for that delay of this 5 or 7 days, whatever they may be, a damage can be claimed, but the entire contract cannot be rescinded, contract cannot be cancelled, or it cannot be repudiated. So in case of this condition, repudiation is there, but in case of this warranty, damages can only be claimed. So that is the basic difference. So in case of condition, it is a stipulation essential to the main purpose of contract, but in case of this warranty, it is a stipulation collateral to the main purpose of the contract. So here in the first case, it is a breach of contract, that is only relating to repudiation. In second part, it is relating to damage, claim of damages. So that is the basic difference between the condition and warranty that is stipulated under our Sale of Goods Act. Now let us discuss what are the things. Some things are there, certain conditions are there, stipulated conditions are there. In case of this condition, what are the conditions? First is implied undertaking. Suppose a person is going to sell some goods. So there is an implied undertaking by the person who is doing the transaction. Sale by description. Suppose some property is going to be sold. So the description of the property must be maintained. So once it is sold by description, it is an implied undertaking given by the seller. So then another thing is called stipulated condition. Any condition that is stipulated therein, it must be fixed or it must be followed. So that is called stipulated condition. The condition, whatever the terms and conditions of the sale, that must be stipulated. As to the quality of fitness and this merchantability. So any condition or any quality of goods that is a condition precedent of this sale agreement or Sale of Goods Act, the condition must be fulfilled. And regarding the quality, whatever the quality that has been contracted between the parties, seller and purchaser, their quality should be maintained. Regarding that, their quality should be relating to fitness. Not only quality is there, the quality should be suitable, fitted to the terms and conditions of the contract. That is called quality of fitness. Similarly, there is an implied condition as to merchantability. Whatever the goods that is delivered, that must be having some value. So that is called value of merchantability. So these things are certain stipulated implied conditions are there. Another implied condition that is called sale by sample. Whatever the sample that is exhibited for the transaction, that must be complied. So that is called sale by sample. So these are certain implied conditions are there. Certain similarly under warranty chapter, these are all relating to conditions. Under warranty also certain implied warranties are there. What are the then quote possession? That means when a possession is delivered, when the property is going to be sold, whatever the purchaser is going to acquire the property, he must possess the property quietly. That means the property must be free from all encumbrances. There should not be any encumbrance regarding his peaceful possession. That is called free from this possession, or that is called quiet possession. So that possession must be free from all sorts of this encumbrances, and the quality of this thing must be maintained. Second is, there is another formula called right of caveat emptor. So in this case, the right of caveat emptor is, this is given under section 16 of Sale of Goods Act. The right of the caveat emptor means when a person is going to buy, he must, before buying that material, he must examine the material, whether that material will suit his purpose, or that whether the material is quite okay for his purchase. If these things are qualified, then only he can purchase. Subsequently, if any defects come out, at that time the seller is not having any implied binding or that condition, for he will not be asked he cannot be asked to compensate. Once, that's why the caveat emptor formula, it is giving the responsibility is not being given to the seller. All the responsibility is given to the purchaser. Once somebody is going to buy, he must be careful before purchasing that material regarding suitability or quality. Everything he must examine. If he is satisfied, then only. So that's why definitely is a paradise for the seller. So this formula, caveat emptor, is also very much applied in case of sale of goods. That means somebody is buying to purchase, or somebody is purchasing some goods. Before that, he must examine the material. If he is satisfied, then he should go for the purchase. So that is the caveat emptor formula is also very much applied of section 16 of this Act. Then now, let us discuss another aspect. What are the rights of unpaid seller? Suppose a seller has not been paid, or it is partially paid and some part of money is remain pending. So that is called unpaid seller. If some money is remain pending, the entire money has not been satisfied, partial money is given, something is pending, it is called rights of unpaid seller. So certain rights are attributed to seller regarding unpaid seller. So first let us examine. So when the seller is having certain right to demand, because his money has not been paid, his money has not been satisfied. So certain rights are given. So at that time the seller can stop the transit. When the property is in transit, he can stop the transit and he can acquire back the property, he can resell. So many rights are given under this for this unpaid seller. So sellers are definitely under the privileged condition under this right to unpaid seller. Similarly, certain rights are also given. So rights against goods. What are the certain rights are also against the goods? What are the rights? First is right to lien. Suppose a right of unpaid seller, the seller has not been paid the entire money, or some money is outstanding. At that time, he is having the right to lien. Unless the money is completely fulfilled, or unless the money is completely paid, he has got right to keep that property in his custody. That is called right of lien. So right of lien is also another right to the unpaid seller. Then stoppage in the transit. When a material is in the transit or in this railway, there is a movement on the way, when the money is not paid at any stage, he can stop the transit. That is called stoppage of transit. So this is definitely another valuable right given to the seller. So these rights are of course given to the sellers only. Then another right is also attributed to seller, right to resell. Once a property is acquired and repossessed, he is having all option to right to resell. He cannot wait for further sale, so he can resell, because if the property is in perishable form, there is every possibility that the property is going to be destroyed or damaged. In that case, the seller has got very option under the right to resell. So these are certain valuable rights given to seller. Similarly, certain rights against buyers. So buyers are also certain rights. So first, suit for price. Suppose a buyer can also case can be filed against for claiming the whatever that is loss is sustained, a price for that price can be, a suit can be filed in the civil court. That is called suit for price. Then suit for damage. Any loss that is attributed against the buyer, that can also be damage can be claimed. That damage can be filed in the civil suit for claiming damages. So that is in any form of claiming damage for suit. Then another third is repudiation of contract. In case of any right that is right against the buyer, a seller can also repudiate the entire contract. That means he can come out from the contract because the contractual obligations are not shown by the purchaser. If there is any deviation by the purchaser regarding the contractual obligation, at that time also the seller has got option to repudiate the contract. That is called repudiation of contract. Then another is called suit for interest. Any interest is entitled under law, a suit can also be filed by the seller against the buyer. So these are some of the rights given to the seller. So rights to the seller against the buyer. Similarly, rights of unpaid seller, whatever the rights, so already we have discussed. So these are some total gist of the entire Sale of Goods Act. So certain valuable rights are given under this act to the seller as well as vis-a-vis the purchaser. So once they are entering into any obligation, so there is a contractual relationship existed, and both the parties are incumbent under duty to perform their duty, contractual duty, obligation vis-a-vis, and both the parties should be very fair in their transaction, and all these things are governed under the Sale of Goods Act. And the last portion of this, that whatever the conditions, that is implied conditions and warranties must be fulfilled, and any deviation thereof, there is a breach. Once there is a breach, the parties can seek their justice before the court of law for seeking justice relating to damage, compensation, whatever loss that is attributed. So all these things are relating to the Sales of Goods Act.